Hello, I'm Alan Fowler from Key West Criminal Defense, where we believe that one bad mistake or wrongful arrest shouldn't ruin the rest of your life. Now, you or a loved one may have recently been arrested and released under the supervision of the Office of Pretrial Services. So what is that, and what do you need to know about it? If you haven't already, please watch the videos that we've created on a first appearance and the videos that we created on pretrial release and the difference between pretrial services and a bond. Now, at the first appearance, the judge will make a determination of whether or not the defendant should be released, and if so, if he or she should be released under reasonable conditions. Now, the Florida Constitution says that everyone is presumed to have the right to be released from jail under reasonable conditions. And in my experience, if you or your loved one have never been arrested before, or if that arrest, if you have a criminal history that has some light criminal matters from years past, odds are that the judge is going to release you without requiring you to deposit a monetary bond, but you will be supervised under the Office of Pretrial Services. Now, the Office of Pretrial Services is an administrative office within the 16th Judicial Circuit. They're basically supervised by the judges, and it's a handful of employees. They call themselves pretrial service officers, but they're not police officers, they're just regular employees. And they created this office before I started practicing law in Monroe County, and I've been here since 2009. My understanding is that because the Florida Keys has a high volume of arrestees who are vacationers and tourists, particularly in Key West, that there was an issue where people were being arrested and then going home and never coming back. And the judges either released them without a bond or with a small amount of bond, and they just never came back. And if you live in Alaska or Oregon or even Georgia or Alabama, you may never have occasion to come back to the Keys, maybe not even ever come back to Florida. And so there were these pending cases that were unresolved where the defendant disappeared. There's a pending arrest warrant for them disappearing, but that is basically unresolved. And the judges don't like that. Part of the judge's job conceptually is to run a forum where the interests of justice can be administered. So in this context, if someone has committed a crime, it is in the interests of society that the government be able to present those allegations against the defendant who mounts a defense, and then a judge, a jury, or some other resolution is reached, right? So, in other words, judges don't want people to flee, run away, ignore it, put their head in the sand. So what they did is they created this administrative office that they call the Office of Pretrial Services. They have a similar office in federal court. This is different. So if you have any experience in federal court, don't apply that experience here. And you may be from a county that has an office of a similar name. Don't apply whatever experience you have there here. View this as a whole new thing, okay? And basically the way it works is if you're released under the supervision of pretrial services, that means that at a minimum, you are going to be required to call in to their office once a week and check in. Before you're arrested, the employees from pretrial services will meet with you, and they will give you the number and instructions on where and how to call, and they will give you a 6-digit number, and they will have you record your voice reading that number into a software and a machine. And so each week when you call in, you will read that 6-digit number, and they have voice recognition software that will marry up that phone call with the initial recording that you made. And I guess the idea is to avoid you having your friend or spouse or somebody check in on your behalf, right? So at a minimum, you're going to have to do that. It's also possible that part of the supervision from pretrial services will require other conditions. And if you've been arrested for any sort of act of violence, like misdemeanor battery or felony battery or more serious, you likely will be given an order to either have no contact with the alleged victim or no harmful contact with the alleged victim. And those orders will be spelled out in writing. If you were to violate that order, like for example, if you were ordered to have no contact with the alleged victim and you call them or you go and visit them in person, that alleged victim could report you, and then you could have your pretrial services release revoked. And I'll talk more about that in a moment, but that's not a good thing. Also, if you have been arrested for any offense that's related to alcohol, like driving under the influence, boating under the influence, drunk and disorderly, things like that, it's also possible, maybe even likely, that the judge will order you to be subject to random urinalysis for alcohol. The same is true if you're arrested for a drug offense like possession of cocaine. The judge may order you to go through random urinalysis for drugs, right? Now, you may be thinking, that's not fair. I'm innocent until proven guilty. And certainly in the case of alcohol, it's legal. Why should I not be allowed to consume a legal substance? I completely empathize with that feeling. In my experience, it is very difficult to get a judge to cancel that condition, and the appellate case law on the lawfulness of that doesn't go well for defendants, okay? But don't fight it if you have it. I mean, when I say don't fight it, what I mean is comply with those conditions. And you can visit with your attorney about whether or not we could modify those conditions. And there are times where these conditions can be modified. Now, if you are in a position where you're unable to comply with either the weekly check-in or the random urinalysis, you and your attorney can petition the judge to modify those terms. It's difficult to eliminate them altogether, but if you have a unique circumstance where you just can't comply, the judge may be willing to modify it. The most common example of this is when you have some travel that is going to prevent you from either checking in or doing a urinalysis. Like, for example, if you are going out of the country or going on a cruise where you won't have cell phone service or you won't have easily available cell phone service, or if you work and live in a remote area where it's very difficult for you to comply with a urinalysis, that might be grounds. I represented a client years ago who lived in the Chicago area, but he worked for a moving company and they specialized in moves of big warehouses and things like that. So they'd go to some remote area an hour and a half away from everything else and load up a warehouse or a factory, and it was virtually impossible for him to stop what he was doing to take a urinalysis. So if you're in that position, please contact us, or if you have an attorney, speak with him or her about modifying those conditions, but be aware it is not an easy thing to convince a judge to do. The final point here is what I referenced earlier, which is about having your pretrial services revoked. Now, just to backtrack and to summarize, you have been released from jail, and the conditions of your release are at a minimum that you have to call in and check in once a week. There might be other conditions. If you fail to do that, if you do not check in, or if you don't do a urinalysis, or if you fail a urinalysis, the Office of Pretrial Services will report that to your judge. And the judge may, and in my experience, very likely will issue a warrant for your arrest under the premise that you have violated your pretrial services, okay? The terms of your pretrial release, which was being supervised by pretrial services. In that instance, sometimes the judge will assign a bond for your release. Sometimes they won't, okay? So this is pretty serious stuff. If you've been released, make sure you comply with your conditions, because if you don't, at a minimum, the judge is going to issue a warrant for your arrest with a bond, and then you could post that bond and be released. And if you have questions and concerns about how bonds work, especially in that instance, watch the video that we have on bonds. But there's a possibility that some judges may order a arrest warrant and the warrant will say no bond allowed, which means that when you are arrested, you will be in jail while your case is pending, no matter how long it takes. So pretrial services, even though it seems like an informal matter and you're dealing with people who seem overworked and underpaid, and the conditions may seem unnecessary based on the severity of the offense, it is not something to take lightly. So comply with those conditions, and if you have any questions about those conditions, or if you may have violated those conditions, or any questions about your case generally, please contact our office and we'd be happy to give you a complimentary case evaluation. Thank you.